Dear friends, welcome back. I hope you are liking the content given in this channel. If you like the content given in this channel, please like, subscribe, and comment. Today, we are going to discuss Nairobi International Convention on the Removal of Wrecks. Its official title is Nairobi International Convention on the Removal of Wrecks 2007. It is adopted in 18th May 2007 and entry into force 14th April 2015. The Nairobi International Convention on the Removal of Wrecks 2007 was adopted by an international conference held in Kenya in 2007. The convention provides the legal basis for states to remove or have removed shipwrecks that may have the potential to affect adversely the safety of lives, goods, and property at sea, as well as the marine environment. The convention provides a set of uniform international rules aimed at ensuring the prompt and effective removal of wrecks located beyond the territorial sea. Now we will discuss the area of application. NWRC is basically applicable in the exclusive economic zone of a state party. If an EEZ is not established, then the NWRC applies in the area beyond and adjacent to the territorial sea of that state party and extending not more than 200 nautical miles from the baseline. The NWRC does not apply to territorial waters unless a state party has expressly extended the application of the NWRC to its territory, including the territorial sea. Basically, what it means, NWRC is generally applicable in the exclusive economic zone of a state party. If a country has not established its EEZ, then it is applicable until 200 nautical miles from the baseline. If a country want to apply NWRC in its territorial waters, then they have to notify to the IMO that they want to extend NWRC in its territorial waters. Now we will discuss what is the liability under the NWRC. The registered owner shall be liable for the costs of locating, marking, and removing a wreck. Liability is strict, which means that a claimant does not need to show fault of the registered owner. Now we will discuss, can a owner escape from liability? The registered owner is only able to escape liability under the NWRC if he can prove that the marine casualty that caused the wreck resulted from an act of war, hostilities, civil war, insurrections, or a natural phenomena of an exceptional, inevitable, and irresistible character. Second, was wholly caused by an act or omission done by a third party with intent to cause damage. Third, was wholly caused by the negligence or other wrongful act of any government or other authority responsible for the maintenance of lights or other navigational aids. Now we will discuss limitation of liability under the NWRC. The registered owner can limit liability in accordance with the Convention on Limitation of liability for maritime claims 1976 as amended. Some state parties have indeed notified the International Maritime Organization of a reservation of their right to legislate for unlimited liability in respect of wreck removal. In those jurisdictions, registered owner cannot limit their liability arising under the NWRC. It means mostly owner can limit liability as per the liability for limitation of liability for maritime claims 1976. If a state has notified that in their jurisdiction owner cannot limit his liability, then registered owner cannot limit his liability as per limitation of liability for maritime claims 1976. In that area the owner has to pay for the full damage. Now we will discuss what is opting in. Opting in means an optional clause enabling states parties to apply certain provisions to their territory, including their territorial sea. As we know, NWRC is mostly applicable to the EEZ until state parties has notified to the IMO that they want to apply the NWRC into their territorial sea. If a country wants to apply NWRC in their territorial sea, then they have to opt in so that NWRC is applicable in their territorial sea. Now we will discuss reporting by the master or the operator to the affected state. The report made to the coastal state must provide the name and the principal place of business of the registered owner and all the relevant information necessary for the affected state to determine whether the wreck poses a hazard, including the precise location of the wreck, the type, size, and construction of the wreck, the nature of the damage to, and the condition of the wreck, the nature and quantity of the cargo, in particular, any hazards and noxious substances, and the amount and type of oil, including bunker oil and lubricating oil on board. Is India party to the NWRC? Yes, but India has not extended NWRC to its territorial sea. If you had liked the video, please like, subscribe.